What's up, everybody? Supreme Decisions here, and today I want to answer a question. Can statements prior to being Mirandized be suppressed? This is one of those things where police officers often arrest someone and not read them their Miranda rights. Why? Because it's a minor issue to the police officer. But here's a quick breakdown. Miranda warnings are only required when custody. The person is in police custody. Now understand what that means. They are not free to leave or in a setting that is functionally equivalent of an arrest. If you are in the back seat, you are supposed to be Mirandized, period. If you are down at the police station, you're supposed to have already been Mirandized, period. These things most police officers do not do. Interrogation. The police are asking questions or making statements reasonably likely to solicit an incriminating response. Here's one of those questions. What's your name? Do you have an ID on you? These are questions or statements that are likely to elicit an incriminating response because remember, any answer can and will be held against you in court. So this goes into your right to privacy. And if both are present, failure to give Miranda warnings makes any resulting statements presumptuously inadmissible in the prosecution's case in chief. Always understand that. You can have statements prior to being Mirandized suppressed. Suppressing pre-Miranda statement. You can argue suppression if you were in custody and being interrogated without the warning. Example, police officers arrest you and immediately begin questioning you. Now, the arrest, they'll say, oh, you're not under arrest, you're being detained. However, you're in handcuffs and you're sitting down or you're in the car and they begin asking you questions and only later read you your Miranda right. If that happens, everything prior to them reading you your Miranda rights is subject to suppression. And those statements are often suppressed when executed properly for the request. Now, exemptions. Here is the most common workaround. Why? Because we always tell people you have the right to remain silent. Most people don't have the ability to. They use the spontaneous utterance or voluntary statement exception. If you blurt something out on your own, not in response to a question, or even if you're yelling at an officer and it's in regards to the question, Miranda does not apply. Those are admissible. Again, you have the right to remain silent, but most people don't have the ability. And if you're yelling something out, it is then voluntary and used in court against you. Now, the public safety exception, the New York v. Quarles, officers can ask limited questions without Miranda if it is necessary to protect the public. Now, one of those will be, where is the gun? That's because they already know there is a gun present. Now, if they don't know and they ask, that is a violation and you don't have to answer that. Now, even if suppressed from the prosecution's main case, pre-Miranda statements may sometimes be used to impeach a defendant if they testify inconsistently later. This is why you must understand you need a lot of times someone else to make sure you're not walking yourself into a trap, which could then bite you in the butt later. And in this, your key cases are going to be Miranda v. Arizona, 1966, which established the rule of the prior Miranda suppressions. Rhode Island v. Ennis, it defined the word interrogation, because you remember, everything I talk about goes through a process, and this gives you the process of what constitutes an interrogation. Oregon v. Elstad, statements made before Miranda warnings can sometimes taint later ones, unless the later waiver is shown to be voluntary. And Missouri v. Siebert, 2004, police can't deliberately lay Miranda to get a confession first, then Mirandize and repeat questioning. It is a question-first tactic by police or detectives. This is one that you must understand and be willing and able to apply to protect yourself. And if you were in custody and questioned without being Mirandized, those statements are strong candidates for suppression. And you have my contact email as well as in the description, you're going to see a link to set up consultations. I'm Supreme, and stay protected.